If it please you, my lady, I appear for the appellant, the Secretary of State for Work and Pensions. My learned friends Tom Royston and Alexa Thompson appear for the second respondent, Ida Jarvis Winget.
Yes, thank you.
Who was formerly the wife of the first respondent, Wilfred Versnick, who now plays no part in these proceedings.
Yes.
My lady, if I could start with some quick housekeeping points.
Certainly.
There's a mercifully short list of things you should have. You should have a core and supplemental bundle and an authorities bundle.
We have.
I think I have an apology to make in relation to the hard copy of the authorities bundle.
Very fact.
The sidelining seems to have disappeared from that.
Yes.
Which I'm afraid I only discovered on Sunday as I was marking mine up. The second housekeeping point is timetable. I've discussed this with Mr. Royston. I'm hoping to be finished by between 2:30 and 3 this afternoon. I wouldn't anticipate being more than 30 minutes or so in reply, obviously subject to what Mr. Royston says in his submissions.
So we'll tip into tomorrow, but probably not the whole of the morning.
Yes. There's an outstanding question of whether the respondent needs to put in the respondent's notice.
No.
I'm not, my lady. I wasn't pressing that point. That was a point that was picked up on by Master Meach.
No, we were confident it was something that you would raise, and appropriately so. So we've had an opportunity of thinking about it before we came in this morning, and we don't think it's necessary in the circumstances.
I've also discussed with Mr. Royston. I think there may be some change of his position slightly on some of the points in response to what I've said in our supplemental skeleton. So what I propose to do is not touch on my supplemental skeleton in my opening submissions, and I'll come back to that in reply, depending on.
Have you agreed that between you as being
depending on how Mr. Royston actually puts the points that we were addressing in the.
Yes, we have, my lady.
My lady, this is an appeal against the substitute decision.
Sorry, just before you launch in, just to tell you that we have had an opportunity of reading extensively into the papers.
I'm grateful for that indication. My lady, this is an appeal against a substitute decision made by the Upper Tribunal Judge Ward back in May 2023. The Upper Tribunal allowed the Secretary of State's appeal against the decision of the First-tier Tribunal back in January 2021, which had allowed Mr. Versnick's appeal against the Secretary of State's refusal of universal credit. That decision was back on the 13th of August 2020. The Secretary of State made that decision on the basis that it was considered that Mr. Versnick didn't have a qualifying right to reside in the UK and therefore was not in Great Britain. Having allowed the Secretary of State's appeal, the Upper Tribunal then remade the decision and allowed Mr. Versnick's original appeal on the basis that he had a qualifying right to reside as a self-sufficient person under Article 7.1b of Directive 2004/38/EC, which I will just call the directive. My lady, we say this appeal arises in stark and surprising circumstances. Mr. Versnick is an EU citizen who, throughout his residence in the UK, has had effectively no resources available to him other than those derived from welfare benefits of various kinds paid to his then wife. Whilst we accept that not all those benefits were social assistance, as the term is deployed in the directive.
Sorry to interrupt you just as you're limbering up, but could you just help me with this? I've been struggling to identify the precise difference between social assistance and social security.
Yes.
And I've understood that carers allowance is social security, not social assistance. Is there a definition, or is it a term of art?
There is. There's a definition in a number of cases, particularly in paragraph 61 of Bray. One of the things I will deal with.
Perfect.
In
Thank
due
you very
course
much. In that case, please
explain.
take it in your own course, but it would be of assistance to me in due course.
Thank you. I'm very sorry to rise, but I thought I'd take the opportunity while my learned friend had paused, we don't. It's not quite right to say they were all paid to the second respondent, because the carer's allowance was paid.
Yeah, well, we understand that.
That's absolutely correct. The Upper Tribunal found, as a matter of fact, and we say correctly, that in substantial measure, Mr. Versnick was living on social assistance, albeit provided to his wife. We say that at first blush, the conclusion that someone who has lived entirely on the host state's welfare benefits, and specifically substantially on social assistance, was someone who had sufficient resources to avoid becoming a burden on the host state social assistance system, is a surprising one. And we say that that first impression is the correct impression, and that the decision of the Upper Tribunal remaking the appeal was in error of law. And we say that in summary for three reasons. The first is we say that the Upper Tribunal should not have taken account of social assistance payments, even though they were paid to Mr. Versnick's wife, as a source of resources that he could rely on for Article 7.1b purposes. Secondly, even if in principle the tribunal was entitled to reach that conclusion, we say it erred in a number of respects in how it assessed the sufficiency of those resources. And then finally and thirdly, assuming that we're wrong on both those 2 points, and that Mr. Versnick had a right to reside as a self-sufficient person up to the point of claiming universal credit, we say the Upper Tribunal erred in considering that the burden that paying him universal credit going forward at couple rates was not an unreasonable burden on the social assistance system. So we say that for any or all of those reasons, this court should allow the Secretary of State's appeal and substitute a decision dismissing Mr. Versnick's original appeal and reinstating the Secretary of State's decision from back in August 2020.
Mr. Cornwell, can I just flag up an issue so that you can come back to help us with it in due course?
Yes.
On the third of those topics, and possibly also in relation to the second of those topics, I'm going to need some help from you on what the role of this court is, because we are an appellate court, and we're not the court of first instance or the tribunal of first instance. And at the moment, speaking for myself, I'm not entirely sure what the test is applying, whether we simply take the decision for ourselves, or whether we have to find that there's been some error of law by the Upper Tribunal, or whether it's some other test.
It's an error of law,
right?
Jurisdiction.
You accept
that? And yes, I accept that. And I say the points we raise are amount of errors of law.
Is the consequence that we then decide the factual question, or that it has to go back?
That's a separate issue. Depend on if you found in my favour on what basis. I mean, there could be if for example you found it in my favour on ground 1, I would say that's the end of the matter. No one suggested there's some other.
I follow, but ground 3.
Ground 3, I would accept that there may well be factual and evaluative questions that would need to be remain undecided, which may need to be remitted.
Okay.
But that very much depends on. I think it would very much depend on how you found. Does that deal with that sufficient for the time being?
Thank you.
Perhaps before we get into the guts of this, there are a couple of preliminary points. The first point is that in social security legislation, the relevant date is that of the Secretary of State's decision. So that's back in August 2020, when the UK was still in the implementation period under the withdrawal agreement. and under Article 127 of the Withdrawal Agreement, effectively European Union law applied in full force for these purposes, so we don't need to get into complications about the Withdrawal Agreement, and there's no dispute about that. The second point, and I know that my Lady Justice King will be well aware of the AT case. This case doesn't raise AT issues. Mr. Versnick was given the opportunity by the Upper Tribunal to ventilate such issues if he wished, and he chose not to. He went instead for saying he was self-sufficient. So those issues don't arise. Third point, I've already adverted to this briefly. Mr. Versnick was originally the sole appellant and then the sole respondent in the Upper Tribunal. After the hearing, Mrs. Jarvis Wingate was added as a respondent, or rather her status as a respondent was confirmed. There's no dispute about this. Both parties accept that's the correct procedure, and again that's as a result of various provisions of the Social Security legislation and the appeal regulations. There's an explanation of that in the supplementary bundle at pages 21 to 22 in Judge Ward's order confirming the second respondent's position. Also, we accept that there is a live issue that she has to prosecute because she's potentially the beneficiary, if this appeal is unsuccessful, of any arrears that will be payable. So with those preliminaries out of the way, my agenda is as follows. Firstly, I'll briefly take the court through the relevant facts. I will then take the court through some of the key points in the Upper Tribunal's decision. I will then look at the relevant legislation, domestic and in particular EU. I will then pull out and address some key issues from the case law, both domestic but primarily from the CJEU. And then finally, after a rather lengthy run-up, I will then deliver the ball and address the three grounds of appeal. So, starting then with the first of those, the factual background. Mr. Versnick is a Belgian citizen, EU citizen. He came to the UK in May 2017 and married the second respondent in June 2017. She is a British national. Importantly for this case, she is severely disabled and was in receipt of a number of what are known as legacy welfare benefits, in particular child tax credits, housing benefit and income-related employment and support allowance, which I'll refer to as ESA. Those all count as social assistance. They're paid on the basis of financial need, or at least in part on the basis of financial need, rather than contributions or the satisfaction of objective conditions. The second respondent also received personal independence payments. Those are not a form of social assistance. They are paid purely on the basis of objective assessments of disability and are independent of financial need.
They don't have to be contributory, is that right?
No.
So the distinction, I know you're going to remind us of the distinction later by reference to Bray.
Yeah.
But the distinction between social assistance and other types of benefit is not necessarily one which depends on contribution.
No. Although Mr. Versnick appears to have engaged in some limited self-employed activity while in Belgium, after his arrival in the UK, he was economically inactive. He did not work, nor did he seek work. Rather, he acted as the second respondent's carer. And in that regard, with effect from the 15th of September 2017, he received carer's allowance. As a matter of fact, that was awarded retrospectively on appeal in May 2019, but it was fully backdated, so no issue arises there.
Was he rightfully paid that on your submission?
Yes, because there are different residence requirements in relation to carer's allowance, so there's no inconsistency. I mean, one of the points that he took in his early stages of his appeal was, how can I be resident for purposes of carer's allowance and yet not for universal credit, which is entirely understandable, but they're just different criteria. And as Mr. Royston has indicated, A, the carer's allowance was paid directly to Mr. Versnick, and B, it's accepted that's not social assistance. It's an important point of context here that under the legacy benefits, while the lead claimant, in this case Ms. Jarvis Wingate, had to have a qualifying right to reside, any partner does not. So Mr. Versnick did not need to have a qualifying right to reside in order for the couple to receive benefits at couple rate.
When you use the expression legacy payments, do you mean all? Sorry, legacy benefits. Do you mean all the benefits to which there was an entitlement prior to the move?
Yes.
To the universal credit system.
Yes, I think there's about 37 different ones, but I mean primarily they were income-related ESA, housing benefit, child tax credit, but also, and not relevant in this case, but income support.
But we're talking about everything that came from the benefit system prior to the geographical move.
Yes, prior to the things that were replaced by universal credit.
Thank you.
Primarily.
But is this right that at that time the social assistance benefits were still payable to J rather than to V, even though the
Yes.
amount of the benefits would be
Yes.
fixed according to the fact they're a couple?
Right. She was the claimant.
Yeah.
But as partner, he was taken into account in the calculation of the benefits. So, which is the point I'm just about to make. As a spouse living in the same household, Mr. Versnick was taken into account in Ms. Jarvis Wingate's claims for ESA, child tax credit and council tax benefit. Upon the marrying, he was added to the ESA claim, and that claim was then paid going forward at a couple rate. But that had other effects. In particular, it meant that she lost the severe disablement premium, and Mr. Versnick's carer's allowance, once it was payable, counted as income, which was deducted from her income-related ESA applicable amount. And again, just to clarify, the backdating after the tribunal appeal in relation to the carer's allowance took account of the fact that there would have been an overpayment of income-related ESA.
So they weren't subject to that nightmare where they get the whole amount and then suddenly someone says you owe us X because we've overpaid you.
No,
they managed to get it right first time round.
We checked that, and it appears that it was done. It was done correctly. So they got the net, as it were, the net amount.
Yep.
So the effect of that was that her income-related ESA was reduced from £197.60 to £150.75 per week, albeit there was an increase in the overall benefits payable to the household of £20.40. My lady, that you may well have looked at this already, but in detail. But there are a number of tables in the Upper Tribunal's judgment at pages 77 through to 79. Which set out how the various benefits were composed and how they were affected. So at paragraph 12, you have page 77, you have the position before Mr. Versnick joined the household. Next page, at paragraph 13, you have the effect, what happened afterwards, once he had joined the household, and then paragraph 14 and paragraph 15, there's a summary of the effects on the various components and the overall position. That's based on some agreed tables that were provided by the parties to the Upper Tribunal after the hearing. Although figures are agreed, the significance of and what one draws from this is not agreed and was in dispute, but that's clear. Those tables are in supplemental bundle pages 14 to 20, but I think they are replicated almost entirely in the judgment.
Can I just ask you this, Mr. Conwell? When the overall benefits payable, and I'm particularly interested in the social assistance element, but when you said that overall increased to some extent, payable to the household, on your submission, is the triggering event for that increase the fact of the marriage? Is that
It's I mean, the marriage and him coming to the UK happened within a couple of weeks.
I appreciate that, but in law, what is? Let's suppose he hadn't been an EU citizen, right? Let's say that he lived in, I don't know, Manchester or something, and they decide to get married, and they're living in Cornwall or whatever. Would there have been any difference in what would have happened?
I'll take that away and double check it, but I think the position is no, it wouldn't, because these provisions, I haven't looked specifically at the ESA provisions, but they usually deal with couples that are living as husband and wife or as civil partners,
exactly,
even if they're not formally in that relationship.
Instinctively, and from my own experience, that seems to be right.
Yes.
But of course, it may not be right, so we need to check that. But if it's right, then could it be said that what that suggests is the triggering event in law is not the exercise of the free movement right of an EU citizen, but the fact of a marriage taking place, and that's what leads to, insofar as there is any increase in social assistance benefits, that's what's happening. Because that's the domestic system the UK has chosen to adopt, which is that it takes the view that if you are living with your spouse, that you ought to get a bit more.
Yes, I mean it's a feature of the domestic regime. The Upper Tribunal and respondents the circumstances in which payment arises is a feature of the domestic regime, but that will have potentially implications for whether or not what resources are available to the appellant, to the respondents, and in the case of the first respondents, that will potentially impact on his ability to exercise the right to reside as a self-sufficient person. Is that?
No, I understand your point, and by all means come back to it, especially when you had a chance to take instructions.
Yes.
So can I just be clear? So as far as the ESA is concerned, before the marriage, and I say the marriage simply, or them probably, I presume it'd be cohabitation actually, that it wouldn't have to be marriage as such. So before the cohabitation of this couple, she was getting ESA as a single person with all the various other benefits that you've outlined to us. Upon them assuming cohabitation, that increased because they were then entitled to couple rate because we're talking about legacy payments when right to reside was rested only with the recipient, the lead recipient.
Yes.
However, overall, the income decreased because the second respondent was now entitled to carer's allowance, and once you took off the carer's allowance, which counted as income, the overall shows us a reduction to the ESA of, looking at paragraph 14, £46.85. Have I got that right?
Yes, but the overall the overall amount of benefit income to the household goes up
by £20.40.
Yeah.
Yes, because although the carer's allowance is deducted from the applicable amount for the second respondent, obviously Mr. Versnick himself gets the carer's allowance. So that as it were, cancels out at the household level. So yes, there's a reduction in the income-related ESA, but overall the household benefits income goes up by £20.40. Now, there's an issue there about how much, what's the relevant thing to look at, speaking social assistance, or whether it's the actual benefits. But that's the basic position.
But to come back to my Lord Justice Singh's point, might one say that the trigger for the overall increase in the household is not residence or even actually the fact of marriage. It's the fact that he becomes the carer and is paid for the caring work he does £67.25 per week.
Well, there would have, yes.
Because if that weren't the case, the position would be as before, would it?
No, because various of the components. Because the couple, I suppose he hadn't done any caring, hadn't received carer's allowance. Then, if we look at the table on page 79, paragraph 14, there would be an increase because they'd have moved from single rate to couple rate, so that goes up £42.45.
Yes.
There's an increase in the enhanced disability premium, that goes up to the couple rate. She then loses the severe disablement premium, but gains a carer's premium. So that's where we get to the £20. It would go up by £20.40.
Yeah.
So that would be an increase in social assistance, going up by £20.40. The carer's allowance serves to increase the total benefits received, but reduce the amount of social assistance.
Yeah.
Does that make sense?
Yes.
Can you only get carer's allowance if you're under in the same household?
No, you can get it for. I think the test is whether you're providing care to
So many hours a week.
So many hours a week, 35 hours a week, and not doing more than so much
Paid work.
But you can provide it to someone.
That's what I thought.
And Mr. Royston is pointing out the person being cared for has to receive a qualifying type of
course. Yes, understood. Thank you.
Right. On the 19th of November 2019, Mr. Versnick was granted pre-settled status, or PSS, pursuant to Appendix EU to the immigration rules. This was a point that Judge Ward considered to be of significance, and so it's important to mention it in the factual matrix. Then from May 2022, he obtained settled status, so that's permanent residence. The implications of that are significant from a benefit point of view, because pre-settled status on its own is not a qualifying right to reside for universal credit purposes, and indeed for other income-related benefit purposes, whereas settled status is a qualifying right to reside. in 2020, Mr. Versnick, Mrs. Jarvis Wingate, and Mrs. Jarvis Wingate's son.
Sorry, forgive me.
Yes.
Is there any difference between pre-settled status and settled status from temporary leave to remain and indefinite leave to remain? I know it arises under the particular arrangements in relation to EU exit and the facilitation of what was thought to be a large number of people and therefore an extension of time. But conceptually, pre-settled status means having temporary leave to remain, does it?
Yes, it's a form of temporary leave to remain, and settled status is a form of indefinite leave to remain. It's not, neither of them are subject to any no recourse to public funds conditions or anything like that. It is in that sense. It's a more straight. It's a straightforward, as it were, status.
But am I right in thinking they're not terms that are defined in the legislation? They're labels that have been used.
Or
are they used in the EU withdrawal?
Yes, they're in the Appendix EU to the Immigration.
They are in Appendix EU.
They're a separate, fiendishly complicated provisions with multiple definitions.
Yes. Well, I was involved in a case that had to consider them, which is why I have some passing recollection.
It's quite painful.
I'd forgotten they are defined terms in that.
Yes.
There's
one set of paragraphs that deals with pre-settled status, and then another dealing with settled status.
Thank you.
But the core point, as your lordship said, is that one's limited and the other's indefinite leave.
Thank you.
And similarly, I've got experience of the pre-settled status not qualifying for universal credit settled status.
Indeed, my lady.
So qualifying.
So the next significant event, which in essence triggered this appeal, is that in 2020, the couple and Ms. Jarvis Wingate's son moved from Cornwall to Devon, which had the effect that they then had to apply for universal credit and move off legacy benefits. And so at that point, it became necessary for both members of the couple to have a qualifying right to reside, as couples make a claim jointly, and they both need to satisfy the relevant conditions, and we'll see that in a moment. They therefore made a joint claim as a couple for universal credit on the 28th of July, and as I've said, that was refused on the 13th of August by the Secretary of State. Universal credit was then awarded to Ms. Jarvis Wingate as a single claimant only. That decision was upheld on a mandatory reconsideration by the Secretary of State. If one goes back to the core bundle and moves on to page 80, there's a second set of tables dealing with how things changed when the claim for universal credit was made, and how it might have changed had they been given granted universal credit on a couple basis. So paragraph 16 has a table setting out the position immediately prior to the claim for universal credit. Paragraph 17 sets out the benefits that the couple received as a result of J receiving universal credit as a single person. So that's the components of universal credit paid to her at paragraph 17, and then the overall benefit position at paragraph 18. And then paragraphs 19 and 20 do the comparable exercise on the hypothetical basis as that Mr. Versnick had been found to be eligible and they could claim on a couple basis. And then for reference, paragraph 21 on page 83 then sets out what the position would have been had Mr. Versnick not been part of the household at all. the Upper Tribunal at paragraph 63 of the decision found that the relevant difference between the position as benefits universal credit was actually awarded to Ms Jarvis Wingate and as it would have been had it been awarded on a couple basis was a difference of £347.07 per month. One of the complications here, my lady, is that legacy benefits were generally paid weekly and universal credit is monthly. There was then an appeal to the First-tier Tribunal against that decision, which was allowed by the Tribunal as a telephone hearing in January 2021, and the Tribunal set aside the Secretary of State's decision and directed that Mr Versnick was eligible to receive universal credit. That decision was on the basis of the Court of Appeal's judgment in Frutilla, which was of course subsequently overruled by the Supreme Court, and also the Tribunal as an alternative finding that he fell within what was known as the carer's lacuna. Both of those grounds are no longer pursued, and for that reason I won't take the court to the First-tier Tribunal's decisions. So the issue that you have to consider was first raised with the permission of the Upper Tribunal during the Upper Tribunal proceedings as an alternative basis to uphold the First-tier Tribunal's decision. That takes us to my second topic, which is looking at the Upper Tribunal decision. The reasoning after the facts, which I've taken you to some of the key facts. The Tribunal then sets out the law and the submissions, and then at paragraphs 38 and following come the Tribunal's analysis of those submissions. I think it's fair to say that the reasoning sort of doesn't necessarily proceed in a linear manner, but to a certain extent circles back on itself at points. That's not meant as a criticism. So what I've tried to do is sort of pull out what I understand to be the main points in the Tribunal's reasoning as to how it got to its conclusions. And it dealt with the issue in two halves, as it were. First, there's an analysis of whether Mr Versnick was self-sufficient up to the point at which the claim was made, and it found that he was. And then, having found that, it moved on to address the question of whether there would be an unreasonable burden on the UK social assistance system were universal credit to be awarded at the couple rate. So dealing with those in turn, dealing first with the question of whether he had a right to reside under Article 7.1b up to the point of claim, I think the first point the Tribunal makes at paragraphs 38 to 41, which is at pages 89 through to 90, is that not all of the benefits that Mr Versnick relied upon were social assistance, but some of them clearly were. Second, the Tribunal finds that Mr Versnick only needed to show that he had sufficient resources for himself, not for Ms Jarvis Wingate as well, as she was a British citizen and was not a beneficiary of the directive. Tribunal then found at paragraph 45 that it would be fanciful to conclude that Mr Versnick was not in substantial measure living on social assistance provided to his wife. The judge then went on at paragraphs 46 through to 49, which is pages 91 through to 92, that he then addressed the question of sufficiency and concluded that as the family was receiving the legacy benefits that the government had decided were appropriate, the Secretary of State couldn't say that the resources were not sufficient, as that would conflict with Article 8.4 of the directive. The tribunal then, as it were, looped back to the question of what could count as resources, and considered that the Secretary of State would then have to say that an EU citizen couldn't rely for these purposes on resources ultimately derived from the host state, but he found there was nothing in recital 10 to the directive or in the case of Dano to suggest, to preclude that, and that there was a line of Court of Justice authorities rejecting any condition as to the origin of resources relied on for Article 7.1b purposes. He then noted at paragraphs 52 to 54 that Mr. Versnick's presence in the household had actually reduced the amount of social assistance that was payable. And so at 56, he concluded that Mr. Versnick had sufficient resources to have a right to reside under Article 7.1b, i.e. in the language of the UK implementing legislation, he was self-sufficient.
Can I just ask you about that interim conclusion? It was really the first half of paragraph 56.
Yes.
I may be wrong, but my reading of that passage is that the judge appears to be placing critical weight on the fact that the addition of V into the household did not result in any increase in the social assistance payable to J, and thus no burden. What isn't entirely clear to me, at least, is what the judge's view would have been about the underlying point of principle if there had been some increase in that burden. In other words, by the point of principle, what I mean is whether you can have regard to the fact that V is indirectly receiving social assistance benefits rather than directly receiving them himself. Can you just help me with how you understand the first half of paragraph 56?
My lord, I think that is what he's saying there. He does seem to be attaching significant weight there to the fact that the amount of social assistance went down because of his presence, and that indeed seems to be picked up later on in the judgment when he deals with the question of burden, and also seems to be his understanding in the. I mean, I know one shouldn't read across from a permission to appeal decision, but that also seems to be his view. One of the problems with the judgment in my submission is the tension between that and the headline position that one can't look at origin of resources at all. Because if that's, it's not quite clear, it's not in my submission clear how the judge actually deals with this. On the one hand, he seems to think that the fact that the resources received by Ms. Jarvis Wingate went down is significant. The social assistance side of it went down is significant. On the other hand, he clearly considers himself bound by the Court of Justice authorities saying that origin is irrelevant, and how one squares those two is in my submission somewhat opaque. But I'll come on to that when I get onto the grounds. But my lord, I think yes, I think that's correct. He seems at that point to have landed on the fact that the amount of social assistance went down as being critical. So that then leads the judge to the second part of the analysis, the so-called Bray analysis. That occupies paragraphs 57 through to 74 of the judgment. And again, I think the reasoning can best be, or helpfully be summarised thus. The first point the judge makes, which I've already alluded to, is that the relevant difference is £347.07. That's at 62 to 63. And on that point, he accepted submissions that I made to him. Next point he makes is it wasn't appropriate to take account of any prior burden that Mr. Versnick had placed on the social assistance system, because he didn't think there was one. And he also considered that the future relevant burden was limited to only 23 months, i.e. up to the point at which settled status was going to be obtained, and indeed was obtained, in May 2020, and at which point Mr. Versnick would become eligible in any event for social assistance. He then moved on to consider the relevant cohort for considering the accumulated impact of similar cases, and defined that at paragraph 71 of the judgment. And he concluded that the cohort was probably a small one. That's at 73. And then going back to the individual burden in respect to this particular couple, he noted that their universal credit would have gone up by 26%, which he considered was a relatively small proportion. And taking that together with the size of the cohort, he concluded the burden on the social assistance system was not unreasonable. And so the right to reside under Article 7.1b would not be lost through the award of universal credit.
Can I just ask you this, Mr. Conway? As a matter of law, is it common ground that it's appropriate to take into account the collective impact? In other words, you take into account a cohort?
Yes.
That's common ground.
Yes, I mean that's certainly the approach that there's a previous decision of Judge Ward's in a case called AMS.
Oh yes.
Second interim decision where he proceeded on that basis. And there's going to be a further decision of Judge Ward in a case called VB, which he handed down judgment on back in August, where he's taken the same approach.
Certainly one of those is in the bundle. Do we have both of those?
You don't have VB. I will get a copy of that.
I think it might be helpful, just in case
I will do that.
Something important.
I don't think there's any dispute. Yeah. It certainly wasn't before the Upper Tribunal. The question was about how you identify the cohort.
I see.
So that
and is it common ground that in circumstances where there has been, so it is supposed for the purposes of this part of the argument, an existing right to reside, and it is lost as a result of subsequent events, it is for the Secretary of State to identify the effect of the burden and its unreasonable quality?
I don't think. I think that's not been determined. I don't think definitively by the Upper Tribunal level. I think we would be inclined to say that there is no burden either way, or the burden is on the claimant to establish that they have a right to reside.
Well, that would be very odd. At least that's how it strikes me immediately. All the information will be within the compass of the Secretary of State. It would be odd if the claimant had to say, I know it's going up by 300 and whatever pounds for me, but I've got to prove that I look at the whole cohort and how that's going to affect the whole social assistance system, in which case I'm going to need a lot of information, please, from the Secretary of State, which is going to take a very long time and involve a very detailed factual investigation if I'm to have that burden.
Yes, I mean there is a practical difficulty that obviously when one gets onto questions of cohort, that will depend upon particular circumstances of the claimant and how one identifies the cohort, and that doesn't necessarily, in fact, doesn't align with the way in which the Secretary of State has obtained information. So it is. But that, I suspect the court may take the view that that's a problem for the Secretary of State. But there are potentially a wide range of ways in which one might want to split up cohorts, and that doesn't. Secretary of State doesn't. Statistics don't necessarily align with that.
Well, I understand that there are legal questions and then evidential questions applying the legal principles, but speaking entirely for myself, I have some difficulty with the concept that there simply isn't an evidential burden on either side. If there is to be an evidential burden, it might more naturally seem to fall on the Secretary of State. But I raise that because that's the way my mind's working, and if you want to persuade me at any rate that the position is different, you may need to do so.
I'll reflect on that. My ladies, that brings me to the end of the second topic. So that brings us on to the legislative framework. What I'm going to do is just to orientate ourselves so that we can see exactly how we get into the issues of EU law that arise. I think the place to start is with the universal credit position. I've already touched on this, but universal credit was created under Section 1 of the Welfare Reform Act 2012, which is at tab 2 of the authorities bundle. If you turn up page 22, I'll take you quickly through that. You'll see at page 22 section 2, which makes clear that a claim can be made either by a single person or by members of a couple jointly. That is then complicated by various regulations, but that's the basic position. We go over the page to 23. Position in relation to entitlement is set out, both in relation to a single claimant and joint claimants. They need to satisfy basic conditions and financial conditions. And then moving on to page 24, the basic conditions are set out, and critically for these purposes, at subsection 141C is the condition that a person meets the basic condition who is in Great Britain. And then your ladyship will see that at subsection 5, regulations may be made specifying circumstances in which a person is to be treated as being or not being in Great Britain. Before we leave this Act, at page 26 you'll see section 5, which sets out the financial conditions, and under subsection 5.2 the combined capital conditions and combined income conditions that apply to joint claimants. So, taking a step back to section 4 and the regulations that are made in respect of specifying which person is to be treated as being or not being in Great Britain, that takes us to tab 4 of the authorities bundle at page 142 and regulation 9. Which specify regulation 9.1 specifies that a person, in order to meet the basic condition, a person is to be treated as not being in Great Britain if the person is not habitually resident in the United Kingdom, Channel Islands, etc. And then 2, a person must not be treated as habitually resident in the United Kingdom, etc., unless the person has a right to reside in one of those places. And then regulation 3 specifies a number of rights to reside that aren't in fact rights to reside for these purposes, including 3C little Roman 1, rights under limited leave to remain under Appendix EU to the immigration rules. And you also see under Regulation 9.4c that a person with a permanent right to reside doesn't need to, if one reads that back with the opening clause of Regulation 9.1, doesn't need to satisfy the habitual residence requirement. So that's just to tee up why we're having this debate, because Mr. Versnick needed to show that he had a qualifying right to reside in order to get through the gateway under Regulation 9.2. So if we then move on to EU law, the starting point for that is the Treaty on the Functioning of the European Union, which is at tab 6 of the authorities bundle, relevant provisions of which are at page 163 and 164. So key provision is Article 20. Article 20, paragraph 1, establishes citizenship of the Union for anyone holding nationality of a member state. And then Article 20, paragraph 2 sets out the rights. Citizens of the Union shall enjoy the rights and be subject to the duties provided for in the treaties. They shall have, inter alia, A, the right to move and reside freely within the territory of the member state. But critically, one sees at the end of Article 20, these rights shall be exercised in accordance with the conditions and limits defined by the treaties and by the measures adopted thereunder. Article 21 makes further provision in relation to right to move and reside. Paragraph 1 provides every citizen of the Union shall have a right to move and reside freely within the territory of the member states, subject to limitations and conditions laid down in the treaties and by the measures adopted to give them effect. Which then takes us to the Citizens' Rights Directive, which is at tab 8 of the authorities bundle. I just want to go fairly quickly through that to pick up on key provisions and just so you have a sense of how it works. If we start at page 168, the first recital links in with those provisions in Articles 20 and 21 TFEU that I just referred you to. Citizenship of the Union confers on every citizen of the Union a primary and individual right to move and reside freely within the territory of member states, subject to limitations and conditions laid down in the treaty and to the measures adopted to give it effect. If we then move on to recital 9 at page 170, which sets out the objective to have an unconditional right of residence not exceeding 3 months. But that is then balanced by recital 10 on page 171. Persons exercising their right of residence should not, however, become an unreasonable burden on the social assistance system of the host member state during the initial period of residence. Therefore, the right of residence of Union citizens and their family members for periods in excess of 3 months should be subject to conditions. So that's harking back to the mention of conditions and limitations in Articles 20 and 21. Another key recital is at page 172, recital 16. As long as the beneficiaries of the right of residence do not become an unreasonable burden on the social assistance system of the host member state, they should not be expelled. Therefore, an expulsion measure should not be the automatic consequence of recourse to the social assistance system. Host member state should examine whether it is a case of temporary difficulties and take into account duration, residence and personal circumstances and amount of aid granted in order to consider whether the beneficiary has become an unreasonable burden on its social assistance system and to proceed to expulsion. Now, just to anticipate things, subsequent case law was also regarded recital 16 as relevant to questions about right to reside rather than under Article 17(1)(b and not simply in relation to expulsion. And final recital to look at is recital 21 on page 174. However, it should be left to the host member state to decide whether it will grant social assistance during the first 3 months of residence or for a longer period in the case of job seekers to union citizens other than those who are workers or self-employed persons or who retain the status or their family members or maintenance assistance for studies including vocational training prior to the acquisition of the right of permanent residence. So that A highlights the special status of the workers and self-employed and also again highlights the fact that it's up to member states to decide whether to grant social assistance in the first 3 months. Moving on then to the substantive provisions, at page 177 we have Article 1 which, as is already foreshadowed in the preamble, Article 1A provides that this directive lays down conditions governing the exercise of right of freedom of movement and residence within the territory of the member states by union citizens and their family members. Article 2 is a definition section for the purposes of this directive, and then for these purposes the relevant one is Article 2.2. Family member means the spouse. And Article 3 defines the beneficiaries. The directive shall apply to all union citizens who move to or reside in a member state other than that of which they are national, and to their family members as defined in point 2 of Article 2 who accompany or join them. So Mr. Versnick was a beneficiary of the directive. We accept that Ms. Jarvis Wingate was not a beneficiary of the directive. However, she does fall within the definition of a family member as a spouse. Moving on, there is then a graduated scheme of residence rights. Page 182, Article 6.1 provides for the unconditional right of residence in the first 3 months. But we'll see in a moment there is some qualification of that. Article 7 then deals with right to reside after 3 months and provides a set of conditions that must be met in order for such a residence right to be enjoyed. A person must either be a worker or a self-employed person, or, critically for these purposes, have sufficient resources for themselves and their family members not to become a burden on the social assistance system of the host member state during their period of residence, and have comprehensive sickness insurance cover in the host member state, or C, actually be a student, and students are also subject to a similar provision in relation to comprehensive sickness insurance, and this time a declaration that they have sufficient resources.
Just before we leave that, in Article 7.1b, where it uses the phrase their family members.
Yes.
On your submission, does that include V's wife?
Yes, it does. And in my submission, the Upper Tribunal fell into a logical error in thinking that one had to be a beneficiary in order for it to be relevant to these purposes. And we'll see in a second when we look at Article 8.4 that it would, in my submission, be a nonsense if the Upper Tribunal's analysis was correct. Just moving over the page, just to note that there are then provisions, again reflecting the privileged status of workers and the self-employed in EU free movement law, allowing workers and self-employed to retain their status in certain circumstances such as illness, accident, involuntary unemployment, and so on. That then takes us to Article 8 at page 185. Particularly draw the Court's attention to Article 8.3 for this. In part, this sets out provisions in relation to countries that have adopted registration arrangements, which the UK didn't. But for registration certificates to be issued, Member State may only require that. First point deals with proof of employment and self-employment. Second point deals with Article 7.1b. Union citizens to whom point B of Article 7.1 applies present a valid identity card or passport and provide proof that they satisfy the conditions laid down therein. So they have to be able to provide proof that they have sufficient resources. And then, critically for the purposes of this case, Article 8.4. Member States may not lay down a fixed amount which they regard as sufficient resources, but they must take into account the personal situation of the person concerned. In all cases, this amount shall not be higher than the threshold below which nationals of the host Member State become eligible for social assistance, or where this criterion is not applicable, higher than the minimum social security pension paid by the host Member State. Now, on a literal reading, one might think that Article 8.4 doesn't make an awful lot of sense, because it says that you can't specify an amount, and then in the next sentence it says that that amount shall be no higher than. I think the way to understand that is that there cannot be a fixed specific amount. As the Court of Justice in Bray says, one can have a reference amount, which is a non-definitive indicator, provided that the Member State engages in some analysis in individual cases. As to the threshold of that reference amount, the second sentence provides two options. One is the threshold can be set at the eligibility threshold for social assistance. So in the UK context, that would be looking at the financial conditions in respect of universal credit under Section 5 of the 2012 Welfare Reform Act, or the equivalence in relation to state pension credit for those over pensionable age. Or the second option that a Member State may take where that criterion doesn't apply is to look at the amount of benefit paid, and that's fixed by reference to Social Security pension. Moving then on to Article 14, we're almost there with the directive. Article 14 is page 193, and that sets out...
Just before we get there, can I just understand how Article 7 and Article 8.4 work together on your case? Article 7.1b seems to define sufficiency of resources, not by reference to any objective criterion, basic needs or anything like that, but simply by reference to whether the person, let's focus on the individual rather than the family for the moment, becomes a burden on the social assistance system of the host member state. And host member states can they have their own different social assistance programs, no doubt subject to a minimum, but above that as generous as they like and based on different criteria and different eligibility thresholds.
Yes.
And so if one looks at 7.1b for the moment, it seems to say within whichever host nation, whichever host state you are, you have sufficient resources if you don't qualify social assistance, and you don't if you do.
Yes.
Is that the right way of looking at it?
Yes. Perhaps a way to illustrate this is that.
Sorry, just before you.
Yes.
Okay. And then, if one then moves on to 8.4,
Yes.
what that seems to be saying is, in the second sentence, which dovetails with it, that if you are above the threshold, the state can't say that in those circumstances you've got insufficient, because you're not drawing on the social assistant system.
Yes.
So that it's looking as essentially at a single aspect in 8.4, which dovetails with 7.1b, namely whether you're above or below the qualifying eligibility.
Yes. I mean,
is that the right way to look at it?
I think so. I mean, the perhaps way to illustrate that is with the Austrian system in Bray. The Austrians had a rule that if you applied for social assistance, you thereby lost you couldn't have an Article 7.1b right to reside. And the Court of Justice said, no, that's impermissible, because that is doing precisely what first sentence of Article 8.4 says you can't do. As a specific threshold, no consideration of individual cases. As we'll see in a moment, the UK implementing regulation deals with this by having two conditions. First, it has a threshold, and then even if you don't meet the threshold, there's a scope for an individual decision by the individual decision maker looking at the circumstances of the case.
And just forgive me, can I just see where this goes? But does that mean that for Article 7.1b purposes, you can on one day have sufficient resources and the next not, or vice versa, depending on whether the government changes the threshold?
Well, it was still. I think the correct analysis would be that it would then require, if they change the threshold. I mean, for example, if there's an uplift due to inflation of the relevant,
or change of government, or whatever, change of policy, whatever it may be.
Yes, that wouldn't be the end of the matter. You may not get through. You may cease to have the reference amount, but then there will still need to be an individual assessment of your circumstances.
I see.
And that's reflected in the UK implementing regulations, which we'll look at in a moment.
Thank you.
So moving on to page 193, Article 14, which sets out the retention, how a EU citizen retains the various forms of right to reside. So Article 14.1 deals with the first 3 months of residence. And that right is maintained as long as the person does not become an unreasonable burden on the social assistance system of the host member state. So although the right is unconditional, there is actually a condition, because you lose it if you become an unreasonable burden, and that reflects Article 10, Recital 10. Sorry. Then, critically for these purposes, 2 provides union citizens and their family members shall have a right of residence provided for in Articles 7, 12, and 13, as long as they meet the conditions set out therein. And then there's provision for member states to check that. And then we have, reflecting Recital 16, over the page at 194, we have paragraph 3, an expulsion measure shall not be the automatic consequence of a union citizen or his or her family members' recourse to the social assistance system of the host member state. Very briefly, just so that you're aware of the scheme, Article 16 at page 195 then provides for a permanent right of residence after 5 years. That, as you'll see from Article 16.1, is not subject to the conditions under Chapter 3, so conditions set out, for example, in Article 7. There are then similar related provisions under Articles 17 and 18 in relation to certain family members. And then the final provision I want to take you to is at page 220, Article 24, dealing with equal treatment. which in a sense
Sorry,
Article
Article 20, did you say?
Article 24, page 202.
Thank you.
That, as it were, lurks below the surface of this case, but is not directly, because it's that provision. In order to be able to enjoy the right under Article 24.1, one needs to be residing on the basis of the directive, i.e. in accordance with the relevant conditions. And then even if you are residing on the basis of the directive in two particular categories, during the first 3 months, and if you're residing as a job seeker, a member state can still derogate under Article 24.2. So that's the directive. Briefly, I want to pick up on the promise that I made a moment or two ago in relation to how the domestic legislation implemented these provisions. If one goes back to tab 5 of the authorities bundle at page 151, regulation 4 of the European Economic Area Regulations 2016 defines various key players: worker, self-employed person, and in particular self-sufficient person, which is defined essentially in the same terms as in Article 7.1b. That's Regulation 4.1c. That is then spelt out in a bit more detail in paragraphs 3 and 4 at page 152.
So sorry, you're just ahead of me. Where are we going next?
152.
Thank you.
Regulation 4.3 and 4.4.
Thank you.
4.3 deals with requirements in relation to family members. Regulation 4.4 is the one that unpacks Article 8.4 in the UK context. So, both for purposes of self-sufficient people and for students, resources of a student or self-sufficient person, and where applicable any of their relevant family members, are to be regarded as sufficient if they exceed the maximum level of resources which a British citizen, including resources the British citizen's family members, may possess if the British citizen is to become eligible for social assistance under the United Kingdom's benefit system. So that is picking up the option from Article 8.4 of using the threshold for eligibility for social assistance. But then we have the element of individual appraisal of individual circumstances brought in by paragraph 4b. If paragraph A does not apply, but taking into account the personal circumstances of the person concerned and where applicable all their relevant family members, it appears to the decision maker that resources of the person or persons concerned should be regarded as sufficient. So that's what stops, that's what makes Regulation 4A a permissible reference amount rather than an impermissible threshold. But the way the 2016 regulations then work is it defines various people, including a self-sufficient person, as a qualified person. You see that in Regulation 6, which is at page 154. Regulation 13 is the equivalent of Article 6.1 of the directive. And then...
Sorry, whoa.
Sorry, that's at page 159.
Regulation 13.
Yes, so so Regulation 13.1 is the equivalent of Article 6.1, and then Regulation 13.3 in relation to unreasonable burden in the social assistance system is the equivalent of Article 14.1. and then Regulation 14, which is page 161, replicates Article, or implements Article 14.2 of the directive. A qualified person is entitled to reside in the United Kingdom for as long as that person remains a qualified person. The very final bit of legislation to look at is at tab 7 of the authorities bundle, page 165, which is Directive 9364 EEC, which is the predecessor, well, it's one of the various directives that were predecessor directives to the Citizens' Rights Directive. This was the directive that dealt with the right to reside of those who didn't have a right to reside on any other basis. And you'll see there, this is an admirably short directive, you'll see there that the second recital from the bottom of the left-hand column on page 165, whereas beneficiaries of the right of residence must not become an unreasonable burden on the public finances of the host member state. Again, picking up an idea that finds expression in various provisions of the new directive. And then Article 1 on the right-hand column defines that the right member states shall grant the right of residence to nationals of member states who do not enjoy this right under other provisions of community law, and to members of their families as defined in paragraph 2, provided that they themselves and members of their families are covered by sickness insurance in respect of all risks in the host member states and have sufficient resources to avoid becoming a burden on the social assistance system of the host state during their period of residence. And then we have an equivalent of Article 8.4. Resources referred to in the first paragraph shall be deemed sufficient where they are higher than the level of resources below which a host member state may grant social assistance to its nationals, taking into account personal circumstances of the applicant and where appropriate personal circumstances of persons admitted to paragraph 2, pursuant to paragraph 2. And then there's an equivalent of the, again, next paragraph gives the option of where that's not applicable, of relying on the level of social security pension. And then we have an equivalent, next page, 166, Article 3. We have an equivalent of Article 14.2 of the directive in Article 3. The right to residence shall remain for as long as the beneficiary of the right fulfil the conditions laid down in Article 1. I mention this because a number of the early cases that we'll be looking at shortly are dealing with that directive. Right, so that catch up with my note.
Yeah, well, thank you. That's outstandingly clear. That was extremely clear and helpful.
Thank you, my lady. Hopefully the clarity will continue.
We're holding our breath.
Probably won't, because we're about to start discussing CJU case law. That then brings me on to I think this is my fourth topic.
I think so. If we're moving on to the authorities, that's topic 4.
Case law, yes. Right. What I propose to do is deal with, pull out from the case law 4 topics that I want to discuss as building blocks. First one, very briefly, is coming back to the question that was raised earlier about what is social assistance. Second one is looking at various cases, various dicta on the underlying rationale for provisions in relation to underlying Article 7.1b and the conditions. And then I propose to look at the case law on what resources can be taken into account, and then finally looking at questions about assessment of self-sufficiency both at the outset and then a Bray type situation. So starting with social assistance, best place to go for that is Bray, which is at tab 22. Now, the various of these cases involved question of whether benefits were special non-contributory benefits and whether they were social assistance. Bray gives a definition of social assistance that is then picked up and applied. Definition for the purposes of the directive, but is then picked up and applied in a number of other cases. So if one turns to paragraph 60 and 61, of the court's judgment, which is page 576, the court addresses the question of what does social assistance in the context of the directive means. It says at 60 that there needs to be one needs to refer to the objectives pursued by the provision, Article 7.1b, as recalled in paragraphs 53 to 57, and not by reference to formal criteria, and refers there to several cases, including the Camarage case, which is in the authorities bundle, but I'm not going to take you to that because that involves slightly different wording in another directive. And then the key paragraph is 61. Accordingly, that concept must be interpreted as covering all assistance introduced by public authorities, whether at national, regional or local level, that can be claimed by an individual who does not have resources sufficient to meet their own basic needs and the needs of his family, and who by reason of that fact may become a burden on the public finances of the host member state during his period of residence, which could have consequences for the overall level of assistance which may be granted by that state. Key points are social assistance as a concept dovetails with lack of resources, because the key defining characteristic is that you only get it if you have insufficient resources to meet your basic needs. And it also connects with the concept of burden. So that's the consequence of reliance on social assistance, is that you place a burden on the public finances of the host member state. Now, in my submission, the definition of social assistance is important here for those two reasons, because it brings in wider concept of public finances in a way that I would suggest later on that Judge Ward didn't give sufficient weight to.
But it's not limited to that which is necessary to meet basic needs, is it? If in a particular state the social assistance criteria, which are income related, are more generous than elsewhere, it's whether you qualify or not whether you've got basic needs which in another state would be put at a rather lower level.
Yes, I mean it's a matter for the domestic state how much they provide by way of social assistance. Where EU law comes in is that provided you're residing in accordance with the directive and you're not one of the people who falls within Article 24.2, the host state has to do so in an equal way, both for EU citizens and for their own nationals.
So conceptually, although the purpose behind Article 7 recognises that there may be a link between the level of social assistance and basic needs, it's not basic needs which is the criterion. It's the level at which the social assistance is set.
Yes. By the
local state.
Yes. We can see that in a moment when we look at another case. The key point is that as the court says at paragraph 60, one's interpreting the concept in the context of Article 7.1b. So that's the context in which one's addressing. They're addressing it here. So that definition is then picked up on in various other cases. So Dano at paragraph 63, which is at page 631. Just down from the top of the page, paragraph 63. Dano. Sorry, that's tab 24.
Paragraph
63. Page 631. I'm not sure that materially differs from what's said in Bray. And again, in Alimanovic, which is the next tab 25, page paragraph 44 to 45.
Sorry, can I just catch up with you? What's the reference?
So, Dano is paragraph 63, page 631.
I have that.
Alimanovic is page 671, paragraphs 44 to 45. Where there's a slightly more expansive discussion. The court refers back to paragraph 63 of Dano and then makes the point the predominant function of the benefits issue in the main proceedings, that's a particular German benefit, is to cover minimum subsistence costs necessary to lead a life in keeping with human dignity.
Just give me a moment for my own part. I would like just to read those two paragraphs.
Yes, of course. I don't think we need to go there because it's pretty much again identical, but same concept is adopted in S and Familien Niedersachsen-Bremen, which is at tab 32, page 904, at page 46.
Sorry, paragraph 46.
Paragraph 46, yes. So that's what in this context, and then just for completeness, in the case of CG, which is at tab 29, the same concept is applied by the court. Page 788, paragraph 68. and then again there's a reference at paragraph 69 to subsistence benefits intended to ensure that their recipients have a minimum means of subsistence necessary to lead a life in keeping with human dignity. So that's similar to the point that's made in Ali Marnovich. So that's the first of the topics on the case law.
Just before you leave that topic,
yes.
Is there anywhere, I'm not suggesting there is, but
No.
Is there anywhere where one can see what the UK regards as its benefits which fall into the category called social assistance as opposed to other social security benefits? Or do we just have to work that out on a case-by-case basis?
I think you have to work it out in the case. Certainly that's been my experience with my present clients. Yes, I don't think there's a central list. I mean, obviously there are cases that have been decided. I mean, we know that universal credit is because the Court of Justice has told us it is, and so on. Obviously there'll be case law where this come up.
And is there anywhere in the EU case law which draws a distinction between resources required for basic needs on an income basis and resources required for basic needs on a personal basis by reference to disability, or which
yes,
as I understand,
that will be,
because I wasn't sure I'd seen it in anything you've shown us so far.
Yeah, the latter will be social security benefits in terms of EU law, because that will be defined on the basis of disability rather than need.
Well, I understand that's your submission. I just wondered whether that is somewhere. I'm sure it is.
It is
somewhere in the EU law. At the moment, we've just seen it. We've just seen a reference to basic needs, which doesn't seem to draw any distinction between the nature of the basic needs and.
Well, I mean, it's tied in with the concept of human dignity under Article 1 of the Charter.
Well, as indeed it would be for someone with disabilities.
Is another matter.
It would be for someone with disabilities.
Yes.
Which, as I understand it, fall on the security side, not the social assistance side.
Yes, they do. I will dig out the. I'll try and dig that. I'll add that to my list of things to do.
Thank you.
Good to have a very quick sandwich. Okay, I think for my part I find it helpful too.
Right. So the second topic is looking at something that we've already touched on with the various recitals to the Citizens' Rights Directive and its predecessor directive, but it's useful just to look at the point in how it's been deployed. I think the useful starting point is Advocate General Gehold's opinion in Troiani, which is at tab 17. And in particular, if you could turn up, my lady, page 405. And perhaps if you could read to yourselves paragraph 14 through to 19 of the, so that's 405 through to 406, which is a useful examination of the difference between the economically active and the economically inactive, and why they are treated differently. then there is, if you move forward to page 415 at paragraph 70, there is a fairly trenchant statement of the position by the Advocate General at paragraph AG 70. Again, perhaps if you could read to yourselves. And then if we...
should we read that in the light of what's previously been said as persons who wholly depend on social assistance will be taken care of in their own member state?
Well, I think that's certainly the paradigm case.
But I thought the thrust of what was being said earlier was it's only if you're solely. It's only if you are solely
yes
a social assistance tourist, as it were, rather than an attempted economic migrant, even if you don't, in fact, earn enough to prevent you from having to be topped up by the social assistance system, that the rationale applies. Have I misunderstood what's here being said?
I think I mean, the key point is that it's is whether you are relying on the social assistance system to a significant degree, to the extent that your burden becomes unreasonable. I don't think there isn't on the face of the directive any sort of intentionality test. It's a question of what you are, what the consequence is, rather than your intentions. Perhaps if we could move on to look at Dano and what the court says there. Now, Dano was a case where the claimant moved to Germany, didn't engage in any economic activity, and was denied a state benefit precise by the application in Germany of a specific provision that bars provision to those who have moved solely to obtain benefits. So that was the context of the particular benefit in that case. If you could go back to page 631, which we looked at a moment ago. And if you pick up the the court is looking at circumstances in which someone can rely on Article 24, the equal treatment provision. If my lady and my lords, if you pick up at paragraph 68 and read through to paragraph 70, yes, if you read through a quite long chunk from 68 through to 80, in which the court analyses the purpose of avoiding unreasonable burden on the social assistance system.
You want us to do that now?
I think that if you could do that now, because it'll be relevant to discussion of one of the points in Judge Ward's judgment. And just for your note, rather than to take you to them, because they basically in condensed form make the same points. But in Alimanovic...
Sorry, forgive me. Can we just go back to the judgment we've just been looking at?
Sorry, yes.
I'm afraid that, speaking for myself,
right,
what I find in this passage is what one often finds in CJEU case law, which is that there are different passages which don't necessarily say exactly the same thing.
No.
So if you look at paragraph 76, Article 7.1b seeks to prevent economically inactive union citizens from using the host member state's welfare system to fund their means of subsistence. On the face of it, that seems to be a very broad proposition.
Yes.
Not actually confined on the face of that passage to social assistance, because it talks about the state's welfare system. But then paragraph 78 has a passage which I think the judge in our case expressly quoted. It talks about, in the lines 3 and 4, it's economically inactive union citizens who exercise their right to freedom of movement solely in order to obtain another member state's social assistance.
Yes.
That appears to be a much narrower purpose being ascribed to Article 7.
Yes. I think the way one reconciles that is to remember the benefit in issue in this case. So there's the general proposition at paragraph 76, and then at 78, court as a consequence or corollary of that is saying, well, then the member state must be able to do what Germany has done in this case, of having this provision which specifically bars you if you've moved solely. So it's a subspecies of the wider class. So I don't in that regard, in my submission there isn't the inconsistency. I've just got to remember what the court is talking about. So
that's very helpful.
It comes back to quite properly. It comes back to the actual benefit that's in question and says
that's very helpful. Can I just ask you this then? As I read it, and I may be wrong, as I read it, the judge's judgment in the case we're considering appeared to emphasise what's said at paragraph 78
Yes.
as being the purpose of Article 7.
And in my submission, that's wrong.
Yeah, your
Too
submission
narrow.
is that it's actually the purpose of the provision is to be found in paragraph 76.
Yes.
Right.
Paragraph 76 may not be read quite as broadly as you suggest, because it is ultimately, it's talking about Article 7.1b.
True.
So when it refers to the state's welfare system, but yes, that 76 in my submission is the key.
Yeah. The link between the two is the reference to solely in paragraph 78 is because we're not concerned at all for 7.1b purposes with people other than the cohort who are economically inactive. We're not concerned with a cohort who are economically active but nevertheless a burden on the social assistance system because they're not earning enough.
Yes.
Because as explained, that's not what this is aimed at.
No. I mean,
So the solely, whether it correctly identifies purpose or effect, it is at least seeking to identify that they're the economically inactive and therefore that they are wholly dependent on the member state's social assistance as opposed to only partially dependent upon it. Is that the right way of reading it?
yes, I think that's
Thank you.
right. As I said, I'm not going to take you to them, but just for your note, there is a similar, more condensed discussion in Alimanovic, that's tab 25, paragraph 50, page 672, and Garcia Nieto, which is at tab 27, paragraph 39, page 715. And also very recently, again in CG, which is at tab 29, the court, again at paragraph 78 to 79, picks up and adopts the reasoning in Dano at 78 and 80 and 81. So that's 789, tab 29, in CG. So all of this has to be, the discussion of that Article 7.1b has to be read in the light of this string of very clear statements about the underlying purpose of the provision. Which brings us on to my next case law topic, which is the penultimate one, which is what do we mean by resources? Or what can be taken into account? And if we go to Chen, which is at tab 18, and the discussion starts at page 447. So Chen was a case concerned with a Chinese couple who were resident in the UK. They moved to Northern Ireland, Belfast, temporarily so that Mrs. Chen could give birth to a child who thereby became an Irish citizen and was therefore able to assert free movement rights excuse me, against the UK. And the question was whether the child could claim a right to reside as a self-sufficient person under Directive 9364 on the basis of the resources of her clearly reasonably wealthy parents. It's recorded there was been no claim for any social security benefits, and the UK and the Irish governments argue that one had to look at the resources, the source of the resources, and that the resources couldn't be those of an accompanying family member. And if one looks at paragraphs 26 through to 33, the court addressed that and reminded itself that the conditions and limitations in the directive were conditions and limitations on the right set out in, as it then was, Article 18 of the Treaty of the European Community, and that those had to be proportionate. It then noted that Directive 9364 set out conditions of not becoming a burden on the social assistance system, and then addressed the objection from the UK and Irish governments at paragraph 29, saying that the child Catherine had to possess resources personally, and the court said that was unfounded. Paragraph 30 is sufficient for the nationals of a member state to have the necessary resources, and that provision lays down no requirement whatsoever as to their origin. And paragraph 31 makes the point that the fundamental principle of freedom of movement had to be interpreted broadly, and while at 32, while that could be subordinated to the legitimate interests of the member state, the limitations and conditions had to be applied in compliance with limits imposed by community law, and that having a requirement as to origin would add to the conditions and be in disproportionate interference with the exercise of the fundamental right of free movement. Now, as I say, as the court noted, paragraph 13, that's at page 445, the applicants do not rely on public funds in the United Kingdom, and there is no realistic possibility of their becoming so reliant. So that's the origin of the line of cases saying that the origin is the resources is irrelevant. The rationale for that is explained a bit further in the next case, which is commissioned in Belgium, which is at tab 19, and this was infraction provisions brought against Belgium, and one of the issues there was the Belgian requirement that the resources relied on by someone claiming a right of residence as a self-sufficient person had to be that person's own income or resources. And the Commission was particularly concerned about an example of a Portuguese lady who the Belgian authorities had refused to write a residence because she was seeking to rely on resources from her husband. Belgian authorities then moved their position and said, well, it's permissible if there is an enforceable obligation to provide the resources. But as my lady and my lords, you'll see at page 470, from paragraph 38 onwards, the court rejected that argument and found that the Belgian provisions were in breach of Directive 9364, and it sets out the rationale in a bit more detail. They start off at 39 by reiterating the points that are made in Zhu and Chen. And then at paragraph 41 identify the requirement as the origin of resources which is not being necessary for the attainment of the objective pursued, namely protection of the public finances of the member state, would constitute a disproportionate interference with the exercise of the fundamental right of freedom of movement of residents, upheld by Article 18 EC. And they then go on and explore in a little bit more detail that rationale and the subsequent paragraphs. Sufficiency, they say, can be met where the resources are provided by a family member. Consideration, this is at 44, consideration of that question essentially focuses on the source of such income, as the authorities of the host member state are in any event entitled to undertake necessary checks as to its existence, amount and availability. And then at 45, they address the Belgian government's contention that such a requirement is justified by the fact that if the account were taken of the income of a person whose link with the citizen of the Union was not legally defined, it could therefore be severed easily, the risk of a citizen becoming a burden for the social security system of the host member state after a certain time would be all the greater. But then at 46 they reject that argument, goes beyond what is necessary to achieve the purpose of the directive, which is the protection of public finances of the host member state. And then at 47 they explain that there's always an underlying risk of insufficiency of resources, and there's no automatic effect on the risk of such loss arising as the materialisation of such risk as the result of change of circumstance. And they point out that the then directive contains provisions allowing the state to act in the event of an actual loss of financial resources, which is the same as one finds under Article 14.2 of the directive. The right only exists as long as the conditions are met. There were then various further cases that instantiate this approach in different factual scenarios, and they repeat without greatly shedding much further light. They repeat the analysis in Chen. So, for example, a Lopka at tab 23 is another case of a third country national who was trying to rely on the resident status of her EU citizen children who are French nationals living in Belgium, and at paragraph 27 the court referred back to the analysis in Chen. That's at page 587. And then again, illustrating the point, is the Kuldeep Singh case at tab 26, page 675, where EU citizens sought to rely upon the earnings of their third country national husband, and unsurprisingly, in light of the existing case law, at paragraphs 74 to 75, page 686, the court again reiterated the approach in Chen that requirement for the origin of resources would be a disproportionate interference with the exercise of the right. Again, there was no suggestion here that the families in question had relied on state social assistance system. That brings us to Vajratari, which is the most recent of this string of cases dating from 2019, which is at tab 28, and which, in my submission, has the most sustained and detailed analysis of the rationale for the court's rejection of the idea that the origin of resources is relevant. And that starts at paragraph 30 on page 742 and goes through to paragraph 42.
Sorry, where does it begin?
Paragraph 30 at the bottom of page 742.
Thank you.
I think if your ladyship and your lordships could read through that, that's the most comprehensive analysis.
These are third country national parents again, are they?
Yes, that's another third country national. In this case, the issue was the parent, third country parent, had been working, but didn't have a residence permit at the time and was working illegally. And the question was whether the children could have a right to reside as self-sufficient persons on the basis of the resources from their father's illegal working. And the answer was yes, because what was being asked was basically a question about the origin of the resources. It was basically an attempt to impose a condition as to origin. But in my submission, the court's analysis of exactly why that would be a disproportionate step is instructive. So the key point from this is that the court considers that there are alternative mechanisms under the directive for addressing loss of resources and sufficiency of resources that might, to the extent that there is an extra risk of loss because the work is illegal, that can be addressed by other mechanisms under the directive. And in my submission, the question of what alternative mechanism there might be for protecting public finances in a case such as the present one is critical to the examination of the first ground of appeal. I'll come back to that in a moment. So my final topic, which I hope I can take fairly swiftly.
Sorry, just before you move on to that topic, have I understood the legal position correctly that the case law of the CJEU on this origins issue has concerned a number of scenarios where, for example, the person concerned may not directly themselves have access to funds, but nevertheless there is somebody else that they can rely on. There may be a parent, there may be other family members. I suppose in principle it could be gifts from third parties, loans potentially. But anyway, it doesn't matter. But is your fundamental point that none of the case law has concerned a situation where the origin of that funding was in fact the host member state's social assistance system?
Yes.
And I think you would go on to say that that would be a line beyond which one ought not to go, because that's what this is all about.
Yes.
They talk endlessly about in order to protect the legitimate interest of the host member state, to avoid someone becoming a burden on the public finances of that member state.
Absolutely, and we would say in this kind of scenario, if the Upper Tribunal is correct in its analysis, then none of the protective measures that the court refers to as already existing in the directive that render it unnecessary and disproportionate to impose an origin requirement, none of those measures work in this context. If it's correct that because if our position is correct, then Mr. Versnick always was dependent on the resources on public finances. He's already in that position, and so one can't rely on Article 14 or the ability to check or anything like that, because it doesn't help. And that was rather brusquely, as a concern, that was rather brusquely dismissed by Judge Ward. But in my submission, it's absolutely fundamental to the rationale as to why, in this kind of case, having some view as to the origin of the resources is entirely proportionate and entirely consistent with the objective. Indeed, it's the only obvious way of meeting the objective. And it's not as if that's the only situation in which that arises. It's actually a decision by Judge Ward himself in a case called VP, which I was going to take you to in a moment, where that was a case under the old accession regulations, where A8 nationals of the A8 accession states had to register in order for their work to count. They could only count as a worker if they'd registered. And this claimant hadn't done that, or hadn't done it enough. And so there were periods when he was working, but he couldn't claim to be a worker. So it was argued on his behalf that, well, he could say that he was self-sufficient on the basis of his own earnings. And Judge Ward considered the cases, Chen and so on, and recognised the general prohibition on looking at origin, but said that in order to give effect to the structure and meaning and content of the directive, one had to look at, one had to recognise there was a fundamental distinction between being economically inactive and being economically active, and you couldn't sort of mix the two up. And in my submission, this is a similar kind of situation. Perhaps if I move on to my next topic, and while doing that, we can have a brief diversion. I can show you where Judge Ward addresses that. So the case So my final case law topic. I'm sorry, this is taking a little bit longer than I hoped, but I think I will then be able to move fairly swiftly on the actual grounds. So we've looked at what resources are. We've looked at the underlying rationale. We've looked at the kind of resources that can be taken into account. And the final step is just to look at how a member state goes about assessing resources. There are very few cases that look specifically at the question of how you would assess self-sufficiency from the outset. Bray, in cases like that, look at it self-sufficiency once it's been accepted that comes to an end. The case where that was looked at is the case I've just referred to, VP, which is at tab 12. There were various issues, a huge number of issues in VP. The discussion of self-sufficiency starts at page 278. This, as I say, this was a case where I think he was a Lithuanian national. He was claiming that he had a continuous period of 5 years residence and was trying to look retrospectively back to say that he had had that status on the basis of some periods genuinely as a worker and otherwise as a self-sufficient person. So Judge Ward addressed the question of how one goes about looking at resources. And there's the helpful discussion on page 284 at page paragraphs 83 and 84. Which, if your ladyship and your lordships could read that. The key points that the judge makes is that person claiming to rely on Article 7.1b has to have the resources, and they have to be resources such as to guard against becoming a burden on the social assistance system, i.e. from a person, as he puts it, running short of money and needing to throw themselves on the mercy of the state. And that they have to have those resources throughout the relevant period that they claim to have a right to reside on that basis. So that's, I think that's probably the most useful discussion in the case law of what it is, what needs to be looked at in order for someone to have the resources in the first place. One then has the situation, as Judge Ward found in this case, where someone has a right to reside and then potentially loses it because they don't have sufficient resources and have to turn to the social assistance system of the host state. And that's the situation that was considered in Bray, which is at tab 22, this is a case about a German couple who had pension from Germany, and I think various other benefits. They then moved to Austria, which occasioned the wife's benefits from Germany being cut off because of her change of residence, and they applied for social assistance and were refused by the Austrian authorities. Shortly after, the Austrian authorities had granted them a residence permit on the basis of self-sufficiency. So the court addressed the question of what a host state could do by way of identifying sufficient resources. We've already touched on that in our discussion about the underlying in relation to Article 8.4. So I think the discussion is usefully picked up at 64, where the court makes the point that the national authorities can't decide that someone would place an unreasonable burden on the social assistance system without first carrying out an overall assessment of the specific burden. They make the point that there's nothing in the directive to preclude nationals of other states from receiving social assistance in the host state. And they note the point that the directive prohibits expulsion being the automatic consequence of recourse to the social assistance system of the host state. That's at 66. And they also note the fact that Article 8.4 specifically prohibits the fixing of a particular amount as indicating sufficient resources. They then go on to say at 68, the member state may indicate a certain amount as a reference amount. They may not impose a minimum income level below which it will be presumed that the person concerned does not have sufficient resources, irrespective of specific examination of the situation. So that's picking up on the concept of a reference amount that I referred to earlier. And then they pick up at 69 on recital 16 and apply the concepts in recital 16 about examining whether the person concerned is experiencing temporary difficulties, taking into account the duration of residence, the person concerned, his personal circumstances, and the amount of aid which has been granted to him. And then they go on at 71 to remind themselves of the primacy of the right of freedom to move. And then at 72, the court provides a more detailed examination of the factors to take into account when assessing whether the burden that would be placed by someone receiving social assistance would be unreasonable. And they recognise that the directive recognises, as they put it, a certain degree of financial solidarity between nationals of a host member state and nationals of other member states, particularly if the difficulties which a beneficiary of the right residence encounters are temporary. That's picking up on dicta in Grzelczak. And then at 75, they make the point that the mere fact that someone has received social assistance isn't sufficient to show that they constitute an unreasonable burden on the social assistance system. And then at 78, they return to Mr. Bray's situation and set out the factors that the referring court will need to look at, which, as you can see, it appears to be clearly tied to the fact that Mr. Bray was considered to be self-sufficient. They refer to the fact that those factors have led those authorities to issue him with a residence certificate. and they refer there to the Commission's point and recognise to adopt the Commission's point about needing to look at the wider cohort of beneficiaries. Before I appreciate we're approaching 1 o'clock, what I propose to do is wrap up the case law and then pick up immediately when I start back with going through in fairly short order the 3 grounds of appeal, which I think hopefully should, lots of groundwork has been done. The final case on this to point to is the case called AMS, Second Interim Decision, which is another decision of Judge Ward. It's tab 13. This was a case where the Secretary of State had accepted that the claimant had been self-sufficient on the basis of her savings, and I think from a small pension that she, and various other things that she got. But the question, having reviewed the case law, Bray, and then the subsequent decisions in Dano, Alimanovic, Garcia Nieto, Judge Ward identified that it was still necessary to do an individualised assessment of whether granting her, in this case, state pension credit would be an unreasonable burden. And at paragraph 46, which is at page 312, through to 313, he discusses in a bit more detail the factors identified in Bray. I'm not going to ask you to read that in the minute remaining. In this case, conducting that assessment, which is then set out in the subsequent case at tab 14, AMS Final Decision, Judge Ward concluded that in relation to that particular claimant, the burden would have been unreasonable, and therefore she didn't have a qualifying right to reside for her claim for state pension credit. Unless there's anything you want me to address.
No, thanks very much. Thank you. So, 2 o'clock, we'll move on to the grounds of appeal. O'clock.